we are now starting with a special session of the Academic Forum, what we call in Slovenian here Akademski Forum. Academic Forum is, as you know, a special venue of the Graduate School of Government and European Studies, dedicated precisely to these kind of occasions. Akademski Forum, Academic Forum is it is there to exchange our ideas, to invite guest speakers, and to foster, to really foster our research. Not just lecturing, but fostering research ideas, and basically to make our school, to improve our school, and to increase the interest of our students, also in the issues that are not necessarily strictly part of our curriculum. As I already told you, it is my great pleasure today to welcome Mr. Paul Mahoney, who joined us from Luxembourg, or now from France, if I'm not wrong. Mr. Mahoney is an ex-president of the EU Civil Service Tribunal, and he was before holding a post of the Registrar of the European Court of Human Rights. So, Mr. Mahoney today, he's going to talk specifically and mainly about the European Court of Human Rights, about its evolution, and about the situation in which the court finds itself today. It's not a very good situation, as you will learn, and since we really have such an honorable guest, such an expert who's had a great career in this institution and in the institutions of the European Union, I think I should stop here and I just hand the floor to Mr. Mahoney. The floor is yours. Thank you once again for coming.
Well, when Professor Jambrecht asked me to come, he said that I was not to choose a very academic subject. I was simply to say some words about my experience at the European Court of Human Rights in Strasbourg, from when I arrived in 1974 as a young case lawyer to when I left in 2005 as the registrar. So what I'd like to talk to you today about is the story of the European Court of Human Rights, where it came from, where it's come from, and where it's going to. And if you look on the court's website, you will see that it has today 150,000 cases pending before it. And that number is going up every month. And that is because despite productivity gains over the last 10 or 12 years, the constant story is one of the court not being able to dispose of business cases at the same rate at which they're coming in. The court improves its productivity each year by 10, 15, sometimes 25%. Same money, but more cases disposed of. But unfortunately, the rate at which new cases are coming in is even higher. So if I just cite you some of the figures, in 2009, there were 57,000 new cases lodged, and the court managed to dispose of 35,000 cases. So there was an increase of pending cases of 20,000. So that's over 1,000 new cases every month, 1,500, something like that, get added to this backlog. In 2010, the number of new cases was 61,000, and the court disposed of 41,000. So they went from disposing of 35,000 to 41,000. This is an increase of 15% in their productivity. More or less the same money, same number of judges, same number of lawyers, they increased by 15%, but they still had a further 20,000 cases added to the backlog. So the shortfall is growing and growing. And just to give you another figure, in May of this year, of that 150,000 applications pending, 30,000 of them were classified as repetitive, well-founded cases. That is to say, cases which reflect the same general problem or systemic problem in the country concerned. So these are well-founded cases. There's been a pilot judgment finding that in this or that country there is a general problem, and there are 300, 400, 500, maybe 1,000 similar cases pending. And they have estimated that those 30,000 repetitive, well-founded cases, if they were dealt with in the normal way, would represent 10 years' work for the court. Now this would seem to indicate that the procedures and machinery existing under the European Convention on Human Rights are no longer capable of coping. Well, how have we got to this situation? And what are the prospects of remedying it? What solutions are conceivable and viable and acceptable for the governments, who at the end of the day have to pay the bill? Well, in 2002, I wrote a short article for Festschrift in honor of a Professor Antonio Augusto Canchado Trindade. That's an exotic name. He's an exotic guy. In fact, he's a professor, Brazilian professor of international law, who at the time was the president of the Inter-American Court of Human Rights, which is based in San Jose in Costa Rica, and he's now a judge on the United Nations International Court of Justice in The Hague. And I think what I can do is I can give you a resume of that article, what I said in 2002, and that will put the current predicament of the court into an understandable context, I think. And then in the light of that, we can see, well, what are the prospects for getting out of that predicament? Well, I began this article by saying that institutions, all institutions, evolve over time. And healthy ones, they adapt to their environment if they are to survive. And that's true of the European Court of Human Rights, as it's true of a commercial company or any other public institution. And the title of this article was The Changing Face of the European Court of Human Rights. It's clear in 1949, 1950, when the convention was drafted after the Second World War, what the drafters thought they were creating and what they thought this court would do was one thing. What it ended up looking like in the 1960s, when it was set up and started functioning, was another thing. And that again changed in the 1970s and 80s, when the court really began to function normally with quite a heavy caseload. And it then changed again when the single court was created at the end of the 80s, and it's quite different now. And it may be that it should, that face, maybe that the face should undergo further surgery, plastic surgery, in the future if it's to survive. Well, I first of all in this article went into the philosophical and historical origins of the convention. In the 1950s, that's just after the Second World War, and also in the light of what was happening in the central and eastern part of Europe at the time, in Czechoslovakia, Poland, etc., with the arrival of the communist regimes, the drafters of the convention, who were the essentially Western European countries, they conceived of the convention as an international collective insurance policy of like-minded states and a policy to preserve, as they put it, the rule of law, political democracy and human rights, and to prevent any backsliding towards totalitarian regimes, whether right-wing, like the Nazis, or left-wing, as was happening in the communist part of Europe. And what they thought is that through decided cases, they would set up a kind of early warning system of governmental oppression and undemocratic tendencies to stop undemocratic regimes getting hold in a country, and also to prevent conflict, future conflict in Europe, on the basis that, on the whole, democratic countries that respect the rule of law do not go to war with one another. They may go to war with other countries in other parts of the world, but on the whole they don't go to war with one another. But then when you come to look at the early formative years of the convention system, so if you look at its function after 1953, which is the year when the European Commission of Human Rights was set up, you don't see a somber panorama of incipient totalitarian regimes being snuffed out. If you look at the foundations laid by the European Commission of Human Rights in the 1950s and 1960s through to the 1970s, you don't see weighty cases raising principled issues going to the heart of democratic society. All right, there were some big cases, the Greek colonel's case, but on the whole, what you see is cautious, slow progress based on small cases, dealing with what one might call the ordinary functioning of democratic society. So if you like, there are two levels of protection given under the Convention. The first level against outright abuse and violation of human rights, as occurred in the Greek colonel's case, when there was wholesale violation of just about every article in the Convention. But mainly the cases were about normal democratic decisions taken by parliaments, ministries, local town councils, courts, and the question was whether the correct balance had been respected. In other words, whether the individual had been made to pay too high a price in the general interest, despite the fact that the measure was taken in good faith and in the general interest. Nevertheless, there might have been a violation of the Convention because one had gone too far in imposing a burden on the individual. And you shouldn't forget that at the time, the right of individual petition was not compulsory, and neither was the jurisdiction of the court, which was set up in 1959. These were optional clauses in the Convention. The states could choose whether they were going to let individuals complain against them. They could choose whether they would allow cases to go before the court, which sat in public, as opposed to the Commission, which had hearings in private. And applications were few. So the Commission at the time, which dealt with most cases, seized on every opportunity, and they gave an individual and careful examination to pretty well every application that came in. And this was necessary to launch the system, and the court, once it got going in the 1960s and 1970s, adopted the same approach of careful examination of the individual facts and circumstances of each case, and the court started to award just satisfaction, that's financial compensation on the whole, suited to each particular case. It's true that at the time there is case law which says that judgments are not, or cases aren't simply a vehicle for dispute settlement of the specific applicant, the specific case. In the case of Ireland against the United Kingdom, one of the few interstate cases that was decided in 1978, the court said that its function is also, and this is a quote, to elucidate, safeguard, and develop rules, the rules instituted by the Convention, And then in the famous case concerning northern Cyprus and the, how shall I put it, the presence of Turkish troops in the northern part of the island of Cyprus, which had the consequence that Greek Cypriot owners in the south were denied access to their property in the north. In that case, the court spoke of the convention as a constitutional instrument of European public order. Nevertheless, if you look at the way the court and the commission were operating at the time, it can be seen that the mission of the European Convention and its machinery of protection had veered from the drafters' broad vision of protecting society against totalitarian regimes, that broad vision of the 1950s, towards dispensing individual justice to each and every applicant who came to Strasbourg. The soul of the system had become individual petition and individual justice. But then the volume started to go up and corners began to be cut. The optional clauses also were accepted by all the contracting states at a given time. And so in 1985, the Swiss government proposed that the Commission and the Court should be merged and that there should be a single permanent European Court of Human Rights. And that came about in 1998 with Protocol number 11. So the result of this was that the system became fully judicialized, its individual petition was compulsory, and the power of the Committee of Ministers, representing the governments, their power under the old system to decide cases was removed. So that you could say the character of the convention had evolved from voluntary, choosing whether to allow individuals to complain against you and choosing whether they could go to a court. It had evolved from that to compulsory, and it had evolved from an essentially political system to a judicial system. And then I had a heading called The Operating Environment of the Court Today and in the Foreseeable Future. I can just quote you what I wrote in 2002. I said then, after 4 years of existence of the new court, the aim defined by the drafters of Protocol number 11 is not being achieved. Without citing reams of statistics, the position can be summed up as follows. There is a continuing explosion in the caseload, with ever-growing delays in disposing of applications. The upward trend in incoming business concerns both the long-established convention countries and the so-called new democracies from the former Soviet bloc. While productivity is constantly improving, the court is coming no closer to disposing each month of the same number of applications as are being received. As a result of this imbalance between intake and output, the total of pending cases is inexorably increasing, and correspondingly the prospect of the court catching up with its arrears of work is becoming fainter and fainter. Thus, a crucial question for the future is whether the convention machinery of enforcement, with its present structure, can maintain its operational effectiveness in the face of a flood of incoming applications. Well, I would say that has not changed at all in the intervening 9 years. The situation has just got worse. Some things have moved on. The convention and its accumulated case law has better penetrated the fabric of domestic law, that's national law, in many of the contracting states, so that the convention is now being applied on a day-to-day business by national judges in many more countries. if you like, subsidiarity has become more of a reality, and repatriating the convention, or the work that the convention does, is more possible in a growing number of cases. I can cite France and the United Kingdom, which, if you look at 10 years ago at the case of the Court of Cassation in France or the Conseil d'État, very few references to the convention. Same with the United Kingdom. If you look today, no, there are many more references. So from that point of view, there is a shift from the international level to the national level in a growing number of countries. And secondly, there is the likelihood of the accession of the European Union to the Convention in the near future, which will bring even more business. And the conclusion that I came to in 2002 was that the mutation that the Convention had gone through since its birth in 1950 was that there has developed in Strasbourg an independent judicial machinery allowing the domestic health of each contracting state to be regularly and randomly checked by individual applications which spotlight weaknesses in the national system. So if you like, from the idea of an early warning system against sliding towards totalitarianism, one has arrived at a sort of random health check. Right? Cases allow countries to be looked at in different areas of their democratic health to be looked at to see whether they are up to scratch. But there are a whole lot of pressures coming from different sources militating in favour of the court standing back from this flood of incoming applications in which each applicant is seeking individual justice and compensation tailored to their particular case. That the court should stand back in order, I said, to concentrate on the general interest in terms of human rights protection for democratic society as a whole in Europe. You shouldn't forget the Strasbourg court is an international legal body above all the national legal systems, and it shouldn't be turned into a small claims court for examining financial details in thousands and thousands of cases without, I think, losing its effectiveness. So in other words, I think it's probably necessary in some way to go back nearer to the essential mission for the Convention and the Court as seen by the drafters in 1949, 1950. That's what I said in 2002, and I think that conclusion is still valid. It's true that in the meantime there has been protocol number 14. You might say, well, that protocol number 14 was drafted in order to help the court. And it's true, that protocol, which came into force in June 2010, when Russia finally ratified, years and years after the other contracting states. And it's true, this protocol made some procedural changes to the machinery intended to streamline the procedure and to help the court with its caseload. Yes, that is true, but if you look at it, you will see that the changes constitute essentially tinkering on the edges, just messing around with details on the edges. As far as the main problem is concerned, I would say it's a bit like a flea bite on an elephant. Protocol number 14 has had a very reduced impact on the problem. Most of the changes that it foresees had already been integrated in practice by the court before the protocol ever came into force, so that the actual positive effect after entry into force is even more minimal than the principle of the changes. The only really substantial change brought in by Protocol number 14 is the change made to the term of office of the judges. Now, instead of it being a 6-year term which is renewable, so you've got some judges who will have been there almost 20 years, it's now one single non-renewable term of 9 years, a bit like national constitutional courts. There is a new admissibility criterion in Protocol number 14 that was meant to stem the flow, reduce the flow of cases. This clause has had no impact whatsoever. I think the statistics show that it's been applied in 0.04% of cases so far. It's too complicated, it's too cumbersome. There are 3 separate conditions that have to be fulfilled. Each one has to be examined on the facts of the particular case. An admissibility condition, a new one, could only be of help if it was simple and quick to apply, and that is not the case with this admissibility criterion in Protocol number 14. The single judge, it's now possible for single judges to look at the admissibility of cases. It's true, 28,000 cases were disposed of by single judges in the first year of its operation. But that again was already been done in practice before it came into force, and there are limits to what can be done within the current framework and the current budget, because the court is seriously underfunded at the moment. Just to give you one example, there are 38,000 Russian applications pending, which are classified as being suitable for allocation to a single judge. In other words, they've been analysed by the registry case officer as being suitable for being declared inadmissible. But they have been left aside. They're stuck in an office at the moment because of lack of resources. The Russian-speaking lawyers in the registry simply do not have enough time to deal with these cases. They have too much work dealing with the substantial cases which do raise a real problem of human rights compliance, where there is a real victim behind the application. Now, the court has been forced to apply its own solutions, which are outside the framework of the convention text as it stands at the moment. For example, they've decided to adopt a policy of giving priority to certain categories of cases that are considered to be more important. For example, cases alleging serious ill treatment, inhuman treatment or torture. Cases concerning the right to life, cases concerning the functioning of democracy, free speech or prohibition of political parties, etc. Now, the consequences of this is that some cases will only be looked at many, many years after they have been lodged. Length of proceedings cases, for example. They won't be looked at even until 10 years after they have been lodged, perhaps not even at all. Now, this amounts to a kind of pre-admissibility filtering out of less important cases, without any textual base in the convention for doing this. As I said, the title of this article was called The Changing Face of the European Convention on Human Rights, and my view is that more surgery is necessary today. If there is no radical reform soon, there is a real risk of the Strasbourg system suffocating, of it seizing up and falling over, just ceasing to function. And at the very least, there will be a loss of credibility because of the inordinate delays. You may see the number of cases going down, perhaps, but that will be because people realise there is no point in applying. You're going to have to wait 10 years or 5 years before you get an answer. So what's the point? Well, in other words, the solution may be that the ineffectiveness of the system is coming to its rescue. Well, it may be wishful thinking, but I do have some ideas for radical reform, and I can let you know what they are if you're interested. One is to keep